assist you with a transaction anywhere in California. So wherever you're doing business, we can help you out. And I know you depend on your title company a lot. You kind of always think of the escrow officer, the escrow side of things. And really our approach is a synergy of having an amazing escrow team and an amazing title team. And that's where Scott turns in. Most realtors I talk to have never talked to an underwriter or a title officer before. It's only behind the screen, maybe an email, if anything. So it's a real privilege to have a title officer that will pick up the phone, speak with you and your clients, help you with these sorts of issues. And Scott's a great free second opinion. So if you're ever troubleshooting anything on the title side, even at another company with us, you can always call on Scott and us. And our goal is to help you close the transaction successfully and ethically. So as Jody mentioned, we have a few more classes coming up with Scott. I'll talk about those at the end. If you want to move closer to the screens, we are going to be having the prelims kind of displayed on there. If you want a copy of the slides after the fact, I'll be emailing those out. And without further ado, I'm going to turn it over to our resident expert, Mr. Scott Heisey, our Senior California Title Officer.
So can everybody hear? Oh, I can hear it. Wow. Guys, thanks for coming. A couple of things I want to say is that I've never seen more attractive real estate agents in my life. So apparently all the good looking ones showed up here today. There you go. The other thing I noticed is that some of the smarter people were like, if this is a horrible presentation, I can sneak out quietly, right? Nobody's going to notice. I'm watching you guys. Okay. There you go. So a couple of things about myself. It's funny as I tell this a lot, but my wife picks out my clothes for my presentations, right? So this was kind of her thing because I just got a new cardigan sweater and she's like, you got to wear that. I'm like, fantastic. But last week I did a presentation for the Contra Costa County Bar Association for state planners, right? They invited me over and it was at a place called the Lesher Center in Walnut Creek, Concord area, right? Had no idea, had never been there before. So I told my wife, hey, I've got the Bar Association. They're asking me to do a presentation. I just make sure you pick out clothes. Great. Get up that morning, my clothes are laid out, and I go, are these appropriate to wear in front of a room full of attorneys? And she goes, attorneys? You said the Bar Association. You know, she's, there you go. It's a good thing she's very pretty. So anyway, but it was a great venue. What was really neat about that Bar Association was it was all attorneys, all estate planning, and we were talking about things like elder abuse, financial abuse, easement issues. I mean, just all this great stuff. And I realized that attorneys are an untapped potential for business. It isn't something that we go and market directly to all the time, in particular the estate planners. Why? Let's go down the rabbit hole just a little bit here, is that we have a group of people, being the baby boomers, who are living much longer. And I do a whole presentation on the elderly and demographics and things like that. But what's interesting is that old people, they're making new ones every day, right? And that's kind of a tongue-in-cheek way of saying that that demographic's growing. With that demographic is that they're moving out of their houses and they're going into assisted living facilities. So what do they have to do with the house? They have to sell them. Or we're looking at probates, or we're looking at other things, life-changing events. So if you guys are thinking the way I'm thinking, that might be something where you want to start working with estate planning law firms or attorneys to maybe get referral business out of that. So look at maybe going through your education process and getting your probate certificates or trust certificates in education to then look more attractive to those attorneys. This just kind of dawned on me in particular in speaking to them because they don't know who to turn to. So if you're front and center with them, you might be that first referral. So I'll leave it at that. My first screen here is the anatomy of a prelim. And everybody, and by the way, my phone number is right there and my email address. You'll get these screenshots if you want them later on. You're all invited to call me for anything, whether it's a prelim issue, an easement issue, an estate issue, anything like that. Because if you're familiar with SB 133, is everybody here familiar with SB 133? Okay, I can't give you anything other than my opinion now. Used to be able to give you guys donuts. I know everybody lost weight off of that one now, but really not funny. Okay, so SB 133 prohibits us from giving out free things. But the one thing I can give you is my opinion based on 40 years of experience. So if you have a problem, the transactions actually with a competitor's office, call me. I'm not going to try to take it away from them, but I want to help you close the deal. Because when we get a transaction, what's our goal? Wow, I had 2 people understand that question. And you have to close to get the commission. So I'm going to say it again. What's our goal when we get a transaction? There we go. Lots more voices there. That's fantastic. A lot of people think the title company wants to stop that from happening. Untrue. We are a for-profit business. So it's in our best interest to help you close a deal. But how are we going to help you close the deal? Communication. So we're going to get into some of the things here about a prelim. How many people here have been in real estate more than 5 years? Fantastic. That's great. So I'm assuming the rest of you under 5 years, relatively new. How many people here read this prelim when it's hot off the press? As soon as you get it. Good. There you go. So I hope at the end of this presentation, all hands go up on that question next time. Don't rely upon your escrow officer to tell you the red flags on a prelim. They may not catch them, or they may be too busy. And in particular, if the market does kick up, they're going to be shuffling so many transactions, they may not be able to catch it. So read the prelim as soon as it comes out, and please do not read it off your phone. You can't see those nuances. Look at it on your computer, full size, and let's go through some of the stuff to check out. So this is just kind of a disclaimer. Here's a prelim. This is really just a preliminary format of what a prelim should look like. Look at the details on this, right? In particular, don't worry about the order number so much, but make sure that your buyers and sellers' names, in particular the seller's name, is correct, right? Watch out for that. This dated date, which is very interesting here, will never be in real time. Depending on the county in which you're doing business in, if you have a transaction in Alameda County, that date from the present could be as far back as 6 to 8 weeks deep. So the data isn't real time, it isn't up to date, and it's predicated on a county processing the recorded information. Alameda County in the Bay Area is the slowest, okay? Santa Clara County is the fastest. Sometimes it's 2, 3, 4 days back, at worst 7 days. So we can catch stuff up to that point, okay? If there's something, keep in mind, because somebody might say, hey, we recorded a deed, but it's not showing on the prelim. Did it record after that date? If it recorded after that date, you will not see it on the prelim. And give us the heads up so we can search the records. We'll have to do it by hand or on the computer and search the county website. We'll find it, add it to the prelim. Don't ignore those things. If somebody says something to you, even if it sounds ridiculous, let us know because it's evidence. Keep in mind that consumers speak a different language than we do. We speak title and escrow and real estate. They don't. They may turn something over to their attorney, right? And next thing you know, it's Bob Smith and Mary Smith, husband and wife as joint tenants, but they went to their attorney to set up a trust. And the attorney mails the deed to the recorder's office, which may take 6 to 8 weeks to record, and we're in the middle of a transaction. Do you think they're going to tell you this? No, because they're like, they must know. I'm going to give you an example of something really funny. Okay, don't worry about taking pictures of those slides. We'll send them to you. Also, something very interesting. So as you'll see here, and I'll go back to it, but I really want to take you to number 8. And number 8 is the vesting on the prelim. It's the name of the person who owns it, right? So what's interesting is that that goes out, and that should be the person that you're dealing with. In this case, it's Robert Johnson, a married man, is a sole and separate property. What's that tell us? That's a good one. She opted out. She conveyed her interest to him. Or he may have inherited the property. His parents passed away. Title went to him. So it's automatically sole and separate if you inherit property. You and I are married, right? And thank you so much for lowering the bar and taking on somebody like me. Okay, you guys, it's not going to get any funnier, so you're going to have to start laughing now. Okay, so let's say you and I are married. Your parents give you a mansion, $7 million mansion in Los Gatos, right? Here you go. They either gift it to you or they pass away and you end up with it. I have no interest in that property. By law, the community property of the state of California doesn't allow me to have an interest in that property until you convey it to me. I would never do that if I were you. Because you know what I'd do with that property? I'd sell it. So what happens here is that we run into a conflict. Most title companies will go, oh, sorry, I need a deed from the spouse. If you were to sell it or take a loan out, they'd say, no, your spouse has to deed off. The law says different, right? So this is the things I know. Okay, now some of you are thinking, wait a minute, what about communal bank accounts, right? We have a shared bank account and there's a loan on the property, right? It's only in your name, but 50% of my money is going to pay off that loan, right? What happens in those cases? Do I have an interest in the property? I've got a yes over here. Do I have any no's? Who's afraid to hold up their hand right now? Nope. Thank you for being honest.
I'm here to learn.
I love that. Okay, so what's interesting about that is that it's sort of the truth. Okay, let's go back to our scenario. You're using part of my money to support that McMansion, and that's fantastic because I'm living there. I pay electrical bills, I help maintain it, but you know what I'm building in that? An equitable interest in the property, not fee title. I have no ownership of that property, right? Now we get divorced. And I'm like, well, I'm owed something because we used commingled funds to support this property. In a divorce, I may be granted a financial connection to that property. It will obligate you to then pay me off. Let's say they call it $50,000, whatever that may be. You have to come up with 50 grand to pay me off. But I'm still not connected to the property, right? There's nothing of record that says I even exist in this case. So what it is it's an equitable interest, meaning that it must turn into cash before I can attack it. So we get divorced, you go to sell the property, I'm going to now come after your lawyer and say, I'm owed this amount of money, and then it goes to court. So generally, it should not slow down our transaction, even if that battle's in place. I would be talking to the attorneys. I'd be talking to both sides to go, okay, what's going on here? Because many of you may have seen this before. It's something called a list pendants. Are you familiar with that?
Yes.
That is, I love all the head shaking in the affirmative. Yes, that is the roadblock. That is the speed bump that stops a transaction from moving forward if there's a conflict. So keep that in mind. So back to the point. Robert
I
Smith.
have a question.
Yes, ma'am.
Who gets the attorney? Who gets the attorney? I mean, who finds the attorney? The title company or?
No. So what it is that, again, I'm so sorry we're getting divorced at this point in our lives, but now you laugh, really. All right. So we'd each have attorneys in this case, right? The title company or the title officer being me, I would say, I want to talk to these people. Because again, if we don't communicate, that roadblock's going to stay in place, right? Or again, you guys as real estate agents are the eyes and ears of every transaction. We don't see them anymore. Matter of fact, most escrow people don't see these people anymore because it's remote sign-offs for convenience sake, right? And that's fantastic that we can do things online. Now we're kind of talking about remote online notaries. People can be in, in the Bahamas and still do their notaries and things like that. That is fantastic. But what's it do? It disconnects us from a transaction. I think there's even cases where you guys never see your clients, right? And be aware of that, by the way. I'm going to kind of sidestep for a second. That is rife for fraud and forgery. That is the biggest part where fraud comes into play. It's all emails, online stuff, and then you discover at the close of escrow after it's closed that that person who said they were Robert Johnson was some guy in Russia pretending to be Robert Johnson. And that's now becoming a huge claim issue for the industry. We're finding that more and more. Not as much in Northern California, more in Southern California. And strangely enough, the Midwest is getting hit hard right now. So keep that in mind. Okay, so we're back to our divorce, right? And we're fighting. So title company, title officer needs to get involved and talk to the two attorneys to go, where are we at and what's the negotiation? Are you going to lien the property? Are you going to put a list pendants on the property to stake your claim in the property? Great. But let's say I did that on our mansion and you're like, I'm not paying that guy anything. My parents gave me that property. So the negotiation takes place. And then what do? We have to wait for a resolution of the negotiation. That may delay our transaction. Okay, if it has to go to court, if I'm really digging in and it goes to court, then we can't close because we have a pending action. Bless you. So we have these issues this way. Now, keep in mind, I've heard this before. I get calls from people going, the title company won't close because this is on title. Well, if you're representing a buyer, don't you want your buyer to have clear title?
Yes.
Yes. What is the policy coverage that's already in the car contract? I'll tell you. It's the homeowner's policy. It's the best policy that the industry can issue, which covers fraud, forgery, litigation, all these things. We don't want to then put a buyer, Haley, right? You're the buyer of the property. You're going to come back and go, I have people knocking on the door. What are we going to do? And the title company's going to go, all right, we might be paying a huge claim on this. Worst case scenario, we're unwinding a transaction. So we don't want to do that. Everybody gets involved. Any questions? You guys can ask questions all along the way here, by the way.
You know, it's that you say, realtors don't see the client. If you take the listing, you need at least see the client.
I would think so, right? But there are cases where there's been no touch, right? Yes, absolutely. This happens a lot of time on bare land,
Yes.
right? Absentee owners, vacation properties, where people aren't necessarily there, right? So when we get a sale transaction, we actually send out a memo to the mailing address that's listed on the property taxes. Doesn't have to be the property address itself. Absentee owners, they live over here, this is a rental, what have you. And then I can't tell you how many times we get back, I'm not selling my property. What's going on? So we've stopped the fraud. Okay, so back to the point here, read that prelim. See that Robert Johnson is the owner of that property. Is it Robert Johnson that you were talking to? If it wasn't, who are they? Anybody have cases where somebody was representing the owner of the property? There should be lots of heads nodding up and down now. Because again, let's go back to the baby boomers. We're going to see a lot of that stuff where children might be representing their parents, right? Things like that. So thing is, they don't have the right to represent them unless they produce something that allows them to do that. Power of attorney, for example, right? Or I get this a lot, that should be in a trust. My dad was in a trust. And we go, uh-oh, because the son or daughter will say, I'm successor trustee, and this is what I'm supposed to do. But we're not finding a deed, deeding the property to the trust. What do? You've been so great so far. Don't let me down.
Go see, talk to people about trust.
You could?
To know how it's supposed to be.
Yes.
So it then comes in the revocable trust.
Well, that's a good point. So let's kind of let's go down that rabbit hole for a second. Let's say it wasn't a trust, right? And generally, if the person who created the trust or holds the trust becomes incapacitated or dies, a revocable trust becomes irrevocable, meaning that it cannot be changed, should not be changed. But do I have any attorneys in this room? Oh, thank God we can talk about them now. Okay. All right. 2 attorneys walk into a bar. No, I'm just kidding. We know no such thing as 2 attorneys in a bar. They're all in a bar. All right. So, boom. Okay. So let's go back to that. So it becomes irrevocable, meaning that it cannot change. You just sparked something. I recently worked on a transaction where mother's still alive. She's incapacitated now. They had an independent fiduciary, right? Because the trust said none of the children or beneficiaries of the trust were allowed to represent the trust itself. Keep that in mind. Why do you think a parent would set up a trust that way?
Trust the children.
Who does? So in these cases, I'm going to use you 3 as the 3 children because there's 3 children, okay? And you're the middle one because this is the one it's really about, okay? So mom's incapacitated, you're the fiduciary, okay? So you're acting in compliance of the trust to keep everybody okay. These 2 decide this one doesn't deserve anything. And they come to you and they hound you to the point to where you give up. Now you're an attorney, You're a fiduciary. You have a sworn oath to maintain the integrity of the trust, and they beat you down so much you gave up. You actually executed a document and substituted them in as successor trustees. This is a true story. The trust explicitly said, you cannot do that. So who's at fault here now? The fiduciary attorney, okay, who now put these two in charge of the trust. You're a special needs, right? By the way, every one of you is over 55 years of age. So you're all in a protected group. You're special needs, right? Not incapacitated, it's a physical thing. Can't work, lots of medical care. The trust actually bought you a small home and it was set up for you to live in it for the rest of your life. The parents were taking care of their children. But these two are greedy and they circumvented that. And so I was working on this transaction. I got the call from you. What do? I'm getting letters in the mail, blah, blah. I'm like, you have to get legal representation. Guess what happened there? She's special needs, can't work, physically can barely move, has no money to pay for an attorney. What happened? These two succeeded. They sold the house out from under her, had her evicted. I haven't heard since. Okay, so just because you put something in a trust doesn't mean it works out in favor of the people it should, right? I know that's a horrible story, by the way. How many of you have more than one child? Okay, I'm going to ask you a question. Do you love them all equally?
Yes.
Do you like them all equally? All right, here's the third one. Do you trust them equally? Be pragmatic about who you put in charge or get a fiduciary. Yes, ma'am.
So because of Prop 19, a lot of people have said this child gets this one and this child gets this one.
Right.
If they die, who actually makes sure that title has got their names on as sole, owners of property?
That's a great question. And so here's one thing. Let's go back to the trust for a quick second, right? So this isn't a trust. Robert Johnson's died. He's got 3 beneficiaries, right? And if I go back to your question, 1 or 2 of these have already passed away potentially. Okay. So the parents passed away. Who's in charge of that? Well, let's go back. So either a fiduciary is in charge or one of these 3 children are successor trustees. God forbid they are all co-successor trustees, because that means they all have to agree on what we're doing, right? Which never happens. Go back to those of you who have more than one child. They can't agree on what kind of pizza to have, let alone what to do with the estate, right? I've got 3 boys. I love them both dearly. All right, and paying attention. I like that. All right, so what happens here is that, let's say the smart thing is that the most honest, prudent one was put in charge of the estate, the successor trustee, okay? And you are now obligated to distribute the trust in accordance to the things that are listed out equally, right? So it says all 1/3, 1/3, 1/3, right? So we close a transaction, proceeds go into the trust account of which you're now in charge of. You have to distribute those assets in accordance with the trust. If you violate that, that's on you, right? Because we did everything we could do up front. The moment you jump the rails, you're accountable to them legally, right? But we can't control that. So we can only take it to the finish line and then hand it off at that point. Okay, so keep that in mind. Did that help answer your question?
This child gets this one and this child gets this
Yes.
one, right? So you're saying that successor trustee has to make sure that each one gets clear title.
You got it. You got it. And by the way, so if we're going to go down that rabbit hole just for a second here. So the assessor's office would look at like for like, right? So I'm going to change it up a little bit. Let's go back to each one of you got 1/3, but you wanted the property. You didn't care about the property. You lived out of state, right? But the trust said 1/3, 1/3, 1/3, right? So it's $1 million. Well, let's say 900,000 because I'm not really good at math. So it's 300, 300, 300, right? And you're like, well, if he's getting the property that's worth 900,000 and you're okay with it, you're all owed 300K each out of the house. Okay, so now the assessor's gotten very smart about this, by the way. They want to read the trusts. right? My son's an assessor at the county of San Mateo, and we debate this all the time because we didn't used to read the trust, and then we realized we weren't getting the tax benefits from it. So you distribute the trust to you three equally, and then he buys you out of 2/3 interest. So the Prop 19 is in such a way, unless you get the house for 900,000, but you guys are compensated somehow else within the trust itself of equal value. Therefore, you didn't really get more, right? And you guys didn't lose anything, so it equals out. I know it's kind of convoluted, but deal with the assessor's office, talk to them. Hey, if we do this, how's this going to go? So it works out. By the way, Prop 19 may be getting repealed because they're already throwing on the books that Prop 13 may be coming back.
Yeah.
Right? So we don't know where it's going to go yet. So the moment we actually figure out how Prop 19 works, they're going to change it. All right. Any? Yes, ma'am.
When the agents get the prelim, do we also get the detail of the trust?
Well, that has to come from the family or the seller themselves. You should all, I believe you guys actually have to have a copy of the trust for yourselves. Do you not?
Yes.
Yeah. So you should. We also needed to read through it
From the
from the seller.
seller.
From the seller.
And then we give it to-
Correct. Correct. Okay. So here's another thing. Well, I'm going to go back really quick here, guys. A couple of things to look out for. Yes.
Attorney records it though. In the prelim.
If they record the deed to the trust, yes. If they fail to do so, which we talked about here, where let's go back to Robert Johnson and the children go, I'm sorry, you guys are going to be the successor trustees for the rest of the day, that you go, wait a minute, dad's property should have been in trust. It's not in a trust. There's no deed of record. Then we may be looking at something called a Hegstad, Heggstad, case law out of San Mateo County, that you still have to go through a probate process. It's a shortcut probate process, by the way. It's to establish that the property should have been in the trust, but failed to do so. If the attorney is still around, thank God there's no attorneys in here. If the attorney is still around, I would go back to the attorney and say, you failed to get the property put into the trust. Okay. Now, many times, and I just found this recently, somebody went, whoa, wow, we found the trust and we found the executed deed. And it was dated 10 years ago. And somebody goes, well, can we still use it? Absolutely. The intent was to convey title to the trust 10 years ago. The fact that somebody failed to do that doesn't negate the validity of the trust. It does place some question marks over it that we probably need to dig into a little bit. But again, how do we get over those little speed bumps that we run into is by communicating. Scott, the kids say the property should be in the trust. What do I do? And I go, let's look at this, right? Now, if they totally failed, we can't find the deed, then we have to get the Hegstad order, which then by order places the property in a trust. Now, of course, that's going to delay our closing, right? So keep that in mind. Now, people are always going to ask, can I do a probate and trust class? But people are going to ask, how long does that take? Well, a Hegstad should not take any more than one visit to the courts, but the problem is getting a court date. So it could take 6, 8, 10 weeks, 6 months, depending on how clogged the courts are. Some of them are able to do it via video, but if you run into that, let me know. I've kept a naughty and nice list of attorneys in the area, so I won't tell you who's on the naughty list, but if you need a reference, I can say, hey, this is one that knows the process really well. So keep that in mind. Any questions? This side of the room is really quiet. You guys are shy, huh? Okay, so let's look at number 9. Oh, I'm sorry, I was going to say something else here. Look at number 3. Again, the importance of a prelim and reading the prelim, validate that we searched the correct property, right? Many times we'll get it where somebody will transpose a number in an email and we'll search the property, the absolutely wrong property, might be the one next door. And then we get to the finish line before we find out because nobody read the prelim. Wow, that's not our seller on there. It's a totally different name. I'm like, you had 4 months to tell us this. Okay, so validate that information. I'm going to tell you an absolute horror story based on this exact situation. We had a condo in a condo complex of like 200 units. The seller's name was Susan Chan, C-H-A-N. The agent misspelled Susan Chan when they initiated the order to us, and they spelled it Susan Chen, C-H-E-N. Guess who lived next door to Susan Chan? Guess whose property got sold? We actually did a correction deed because she goes, my name's misspelled on this. And we go, oh, Susan Chin, or Susan Chan, who acquired title is Susan Chin, right? So we went, oh, it was a typo. It was the wrong unit, literally next door, right? So when the tax bills came out, I get a call from Susan Chin going, you sold my property? I'm like, uh-oh. Susan Chan moved to Texas. She was a medical doctor, right? Like a brain surgeon specialist type of thing. It was almost impossible to ever get a hold of her, right? And of course, she's like, oh, I sold my property, you know, type of thing.
The owner, signature and.
We got it.
other stuff.
We got it because it was next door and nobody told us, by the way, that the unit number was incorrect, right? Because it was unit 212 and it was unit 211, or yeah, 212, yeah, and 211.
It's fault.
I would like to say so, but I think it was the title company's fault as well. It was transposed, but there were several instances to correct it that everybody skipped. Why? Because everybody assumed somebody else would catch that problem, right? And so that was the most egregious thing I've ever seen. I'm going to give you another example, all right? So to a situation where we need to read the prelim. Let's go back to the vested owner. Had a transaction that had 4 people on title, all siblings, 25% interest each. You 4 young ladies here are going to be sisters, okay? 25, 25, 25, 25. And you went to sell the house. Great. Who wants to be the real estate agent? Yeah, you don't want to be the agent on this one, so don't raise your hand. All right. So the listing agreement is signed by 1, 2, 3. Prelim comes out with 1, 2, 3, 4, 25% each. Get down to signing, escrow officer calls me, Scott, I think we have a problem. What's up? Sister number 4 didn't show up to the sign off. I said, why? She's dead. She's dead. Now imagine this took 4 months to close. I go, did she die between opening and closing? No. She died in 1996. So we had almost 4 decades to establish the sibling's death. By the way, sisters 1, 2, and 3 never said anything when the prelim came out. They said it, oh yeah, no, our sister died years ago, right? The agent obviously didn't get that 4th signature and did not read the prelim. Who's failing here? Okay, guess who got the finger pointed at them? How could you let this happen? I'm like, I don't know if they're dead unless they are dead of record, right? To me, of record, you were still alive. I'm sorry, what's your name? Karen. Karen was alive, right? You're not now. I'm sorry, Karen. So to make it even worse, right? Karen was entitled as to 25% with her spouse as joint tenants. I'm like, hallelujah. Affidavit of death, joint tenant, spouse can take over that other side. We'll just go back, have them sign the listing agreement. Time out, Scott. They got divorced in 1994. I'm like, not of record. Okay, second part of it was, makes it even better. And you got married to somebody else in between 94 and 96. I think that was the demise of the marriage, actually. All right. So I'm looking at probate. I'm looking at a newer spouse, your newer spouse, right? Who should have a community property interest in this potentially, right? Except it was acquired before marriage. So no, technically on the community property side, no, right? It wasn't primary residence. It was a property that was in the family for generations. It was a vacation home. And they just got old enough to go, nobody's using it anymore, let's sell it. And it was in the Tahoe area, so it was worth a lot of money. Makes perfect sense. So What do you think happened with that transaction? Anyone want to take a stab at that? Ooh, you have great faith in me. How many people think I could close that transaction without probate? Show of hands. Oh wow, I got a couple of people who believe in me. How many people think we had to turn that transaction away? No hands go. I love this. People are just afraid to commit, right? Right. Okay. I closed that transaction. This was a Friday that we found this out. We closed it on Tuesday, right? You want to hear how? All right. Here it goes. So I'm sorry, Karen, I'm taking over your dead spot right now. I'm dead. You're my ex-wife. You're my new widow. Okay. So I got you guys on the phone, which I was thinking is going to be just the battle, right? And you started laughing. Wait a minute, what? I've inherited what? I'm joint tenants on what? And you're laughing. You weren't very happy about that. And so what happened was you go, well, I was actually compensated in our divorce in 1994, $30,000. So I paid you $30K for your interest in that. You've already been compensated, even though of record, nobody did anything. And again, who should have done something with that? The attorney. Who said attorney? Here you go. It's okay to say it out loud. Right? I mean, if you're right, sing it. Of course, if you're wrong, I'm going to point it out too.
Yeah.
All right. So what happens here is that you're like, it's good. What do I do? I'm like, there's no fast and easy way to get out of this. So I pretended I didn't hear about the divorce decree, knew nothing about that. I read it, threw it away, didn't see it. Okay. Said, you two work out an agreement to where we do an affidavit of death of joint tenant, that interest goes to you, and then check goes to you, and then you endorse it over to the widow who is actually entitled to it. And you wrote up a quickie little agreement between the two of you. You passed that 25% over, less any tax implications you had. We closed it on Tuesday. Okay, so keep that in mind because it was a solution based on communication.
So when, in the process, didn't you have to fill in the SI form, the statement of identity?
Sure.
So you don't have that on this form?
Well, yeah, we had amongst the three who are still alive. The fourth person couldn't fill out an SI, but there was no liens on anybody, so it wasn't a problem. We ran all the names. Title was clear, right? The only issue is that Karen, you're dead again. Karen was dead, right? And we had to establish that Karen died. Where does her interest go to avoid a probate? Otherwise, if you two didn't cooperate, we're looking at probate and we're looking at 18 months potentially before we could market that property. Look how it failed. It failed from the very beginning, from the vesting on. Read that prelim because your red flags are going to start right there.
You know,
Right.
when you have the trust and all that many years ago, you still have to update it, but I think people don't know that.
Well, that's a good point. That's a totally kind of different seminar type thing. If any of you have a trust and that trust is older than, let's say, 10 years, look at your assets, look at these things, update that trust. By the way, when I see a trust in title that is from the 80s or the 90s, I know something automatically. What do you think that is?
Some years that.
Potentially that as well. The first thing that I see is their age. When I see a trust established that far back, I'm like, they're probably incapacitated at this point, which triggers a whole lot of things that we have to deal with. So you guys being the eyes and ears of any transaction, if we have a trust that's very, very old, are you dealing with that person directly? Or are you dealing with a representative of that person? And if it's in a trust, then you're probably dealing with the successor trustee. We need the trust immediately to identify the successor trustee to make sure they act in compliance. If there is not in a trust and that person, Robert Johnson, was still alive, are they using a power of attorney? Was that power of attorney executed, let's say, a year or two ago? Is it a durable power of attorney? Or was it executed recently and they're possibly incapacitated when they executed it? We have to watch out for things. Why? Here it is. Here's the kicker, guys. If you're representing a buyer and we have some questions on a prelim or capacity, the policy to the buyer covers them for fraud, forgery, incapacity of seller, ding, 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 and voidability of contract. All of those would exist because if I have an incapacitated seller and I have somebody using a false documentation to represent them, then the contract can be voided. And we don't want that. That is like worst case scenario.
I don't know, a lot of agents. Now, that's why I'm telling you about. We don't know about all this, stuff.
That's why you call me, right?
No.
Scott, I don't know.
Trust is old. I mean, don't the escrow officer read it first?
No.
Or-
So the escrow officer, think of this, escrow and title are on opposite sides of the fence to share a common goal, right? Escrow processes the contractual paperwork between a buyer and a seller, including the agent and or lender. I'm purely underwriting a transaction. If we want to put it into football terms, right? You guys are the quarterbacks of the transaction, right? Escrow is your offensive line. Their job is to move that forward as best they can. Title is defense, right? Remember, offense and defense are still working towards the same goal, which is winning the transaction and getting it to close, right? Without incurring additional liabilities. That's why if you don't know stuff, which is absolutely fine, because you should not be required to know every nuance of every situation, use us as your team. The stuff I know, right? I've been doing this for 40 years. You cannot know what I know. I do not know what you know, right? So you're like, wow, this is weird. I don't know what to do. Call me, email me. Yeah.
Attorney is forgery.
Potentially. It can be unwound. And I'll give you a really quick example of that situation. Matter of fact, I'll use you too. Okay. Properties in a trust. Okay. And I'll weave in a power of attorney situation in a minute though. Properties in a trust. I love dealing with trust because trusts deal out in specificity what's to happen with the property. It's a menu that we get to follow, and I go, successor trustee has to follow this, right? In this case, it was mom. Mom was elderly. Trust was from the 1980s. And I asked for a copy of the trust, as we always do. I was provided an amendment to that trust, right, in which you were the successor trustee, but it was executed shortly before escrow was open. And I went, huh, okay. So I've got a new amendment to a trust, and the daughter is now selling the property the moment she was entitled or got power to do so. Now it's a red flag, doesn't mean it's bad. I just need to double check that. Why? Because let's say mom was incapacitated, needed help, couldn't live in there, and it's kind of an emergency thing. Great, we got to do that. But you would refuse to give me a copy of the entire trust, only the amendment to the trust that gave you ultimate power. That's 2 red flags in a row, right? So here's the kicker is that I finally had to say, I cannot move forward until you surrender all the data, put all the cards on the table. I read the trust. What happens? You're actually the first successor trustee, right? Siblings, brother and sister. It is absolutely normal for the oldest son to always be appointed the successor trustee to the trust. It's a historical thing that baby boomers do because boys are smarter than girls. So I'm kidding. I'm not kidding. So what happened here in this case is that I looked at it as fraud, forgery, right? What's she trying to do? The property was free and clear, worth millions of dollars, right? But what it really was is that you took care of mom. Mom lived with you, right? Day after day, you took care of her. Doctor's appointments, did all these things. Well, so when she slipped in incapacity, you went, wow, we got the end is getting near. I got to move her to an assisted living facility. You dummied up an amendment to the trust, right? And basically, because here was the kicker. I said, why isn't mom just executed this document? Why is she not acting of her own accord if she could sign something so recently? You said, because she has mental incapacity, which immediately voided that. The problem is that you two hated each other. Okay, so what do we do in that case, guys? Right? You go, well, wait a minute, she just committed fraud, right? And again, not to take the money, but because she hated her brother, right? They'd not been in touch in years. The kicker is that you're really the one who's legally able to act because mom couldn't execute that amendment to the trust. So we closed that deal because I talked to you, we unwound the listing agreement, re-executed all that stuff. Mom was going to an assisted living facility. The proceeds were going into the trust of which you were in charge of. She was very angry about that situation, which I can understand from a personal level, but from a legal level, we made it right. But it took that communication, right?
Make it right, like what? Get the money, the other person gets the money back?
Well, money went into the trust, which is where it should go. It wasn't ever going to go to her anyway, but she really didn't have the authority to do it because she did it through fraudulent means.
What if she created another fraud, transferred the money overseas to another country then?
Well, if she does that post-closing, we cannot change that. That's still on her.
Jail?
Oh, well, you know, it's so funny. Do you feel like a criminal now? Because we're just pointing this out to you. It's fun. I use people in all of my presentations, and suddenly you take on that persona where people are going, she's a criminal. I know it.
I had an instance where the sellers had a trust.
Mhm.
So they asked me to find out. And the attorney has gone somewhere, dead or no more available. So
Yes.
What do you do?
Well, then that may end up going to court to ratify some things, right? If a trust has a situation where it appoints trustees, and those trustees, generally it's 1, 2, or 3 different trustees, if those trustees have passed away and there's no successor trustee, then it may have to go into court to then appoint a trustee to act on behalf of the trust. So we're looking at, again, a minor probate situation. But how do we establish these needs and these things? And I'm going to tell you something. I've been doing this for 40 years. The previous 30 did not prepare me for the last 10, because this is all I deal with now. And the reason I deal with all of this now is because of the aging baby boomer population and the fraud and forgery that comes from that.
The internet.
Well, the internet's to blame for everything at this point, right? Yes, ma'am. Yes, absolutely. No, I don't. All right, this stays in this room. That if a title company is asking for an SI, statement of information, on a buyer, I would ask them why. Why do you need to vet the buyer? Because any liens that the buyer may have will not circumvent purchase money, deed of trust. They attach post that, so they would all fall and attach to the property after the close of escrow. Therefore, they cannot supersede anything. The other part of that is that if we are running a buyer's name, right, without being prompted by, let's say, a lender, right, we're now entering into a credit reporting thing where we're viewing them for credit worthiness, which we don't want to do. That's not a part of our job, right? Now, I know other states may act in a different way. There were some title companies in California that were doing that proactively. I'd say do not do that. I think that puts us all in a position, because if we get the SI, are we obligated to run the SI? And if we find things, who do we disclose them to, right? If the lender's already said, I will lend you $900,000 to buy this home, who am I to come in and say, you sure you want to do that? They owe $250,000 in IRS liens. What does that just do to our transaction? Right? We're here to make money, not kill deals. And any liens would not be significant or relevant to our transaction anyway. So I've heard this, that scares me a little bit. All right, so let's jump in really quick. So first thing you're going to look out for is taxes on here. There's something on here, and number B, letter B on there will be on every prelim and policy issued in the state of California. It's because we cannot control supplemental taxes, right? The tax assessor and tax collector work independently. And again, my son being an assessor in another county, it's kind of like his job is to go out and look at properties all year long. So therefore he's like, hey, that property went up by this amount, given their algorithm, right? And this one went down by this much, given the algorithm. So the bills are adjusting accordingly all the time. Okay, back to your Prop 19 comment, right? That's another thing where they're like, is this taxable? Is this not taxable? So it's all over the board. So we just don't cover supplemental taxes because we don't know what they're going to be. That is the Wild West. Okay, so but So that will be your tax section. We get into exceptions. Keep in mind, people often think that things under exceptions, which the word should tell you they're exceptions, meaning not covered by the policy. A lot of people go, oh, I'm covered by that stuff. It's just the opposite. You are not covered by exceptions on the policy. So keep that in mind. And if you thought the otherwise, do not raise your hand. I will not point you out. Okay. But that's okay. And to tell you the truth, I was in the business for like 5 years before I understood that concept. Okay. So these things are not covered. Usually you'll see either CC&Rs or in easements or in first position, right? So if we look at that, the easements might be from a tract map. They might be recorded easements. CC&Rs, all of you should be familiar with CC&Rs. I actually got a call recently, this week, from an agent who's like, my client has a question. We have a property that we're selling. It's on a 1 acre parcel. I said, okay. And they go, but there's a home on our 1 acre parcel that is selling, and the person buying it wants to develop that 1 acre parcel and put 8 smaller homes on it. Now, these are all in a very affluent area of our county where the homes are worth north of 5 up to $10 million each. So those people in that subdivision are like, well, we don't want 8 little houses here, right? The CC&Rs say 1 acre parcel per home, per property. Yet the buyer is trying to invoke, what's it, SB 330, I believe it is, that for the affordable housing thing, which I found kind of tongue in cheek, because if that property is in Saratoga or Los Gatos, is it truly going to be affordable housing, right? It's like, how did that help the people who could not qualify for homes, right, in Saratoga and Los Gatos? Oh, I'm just quasi-rich, so I can take this one, right? I only make $1 million a year, so that's the perfect house for me. So think of it that way. I thought it was kind of funny. But which do the circuit CC&Rs trump the SB? See, I got a no and a yes here. I don't know. This is something that's going to have to be fought out either at the local courts within the city, because if the city approves that, they've now said those CC&Rs don't matter. Wow. And I'm like, uh-oh, this is going to be a problem. So it's interesting, you know, where, and again, I mean, a very affluent area, the CC&Rs were absolutely clear as to how this would go. Now, those CC&Rs were from about 1978. So keep that in mind. Read the CC&Rs. Have your, well, you don't have to, have your buyer read the CC&Rs, right? Now, they'll check the box. I've read everything. I've read and approved everything. But then I get a call 6 months later saying, hey, I've got this problem. And I'm like, well, line number 4 of the CC&Rs state this. They go, I didn't know that. I'm like, I can't help you, but they're angry. And I'm recently dealing with a claim where the agent is defending the buyer on something that was accepted out and read and approved. And of course, everybody's pleading ignorance. And I said, that's the problem. Read the CC&Rs, read the documents, read the prelim. You cannot advise. Neither can I, actually. And of course, people defer that to me. I can use ambiguous terms like, yes, it looks like that to me. Maybe you should talk to your advisor or your attorney to be more clear. And this is what you guys have to do as well. However, like on things like easements and things like that, I understand that's weird. Nobody understands that stuff. I'm here to actually define that. I'm like, yes, this is where it is. We've plotted, we've planned it. I'm not actually giving advice. I'm giving factual information, just helping them understand it. So, yes.
Especially this one, the exception and the CC&Rs
Yeah.
and right? They have the rules written in some documents. Does any title has a red flag there shows up, or it just says you read it?
That's exactly what it is. Why we don't dig into the CC&Rs and say, hey, watch out for this, or this is a law, or this is because, back to her point, we're interpreting that document. We're giving it legal advice as to the effect of that document, which we cannot do, right? That's why if somebody reads it, you know, listen, I would read it and understand it better than most, better than the consumer, right? But I can't advise. I can just say, yes, read this section. This, if I were a buyer, this would be of concern to me. You need to talk to your real estate attorney about the effect of that sort of thing. Yeah.
So when it's a special assessment, where does that show?
That should show up in the tax bill, but if you're talking about a PACE or a HERO loan on top of that, then it should be broken down as an exception as well, right? Because many times it's an exception on the policy or the property, but the payment is tied into the tax base. So you have a double whammy there. What's interesting about that is on the PACE HERO loans, if they're defaulted on, they kind of can go back into the taxes and take precedent over everything else, which is kind of scary, right? Because if you guys remember Mello-Roos, right? Mello-Roos, if you don't pay your taxes, they separate the Mello-Roos out and then they go, we can foreclose upon this section separately, which is faster than foreclosing through the tax process, which is 5 years plus. Mello-Roos could go much quicker than that. So we have to double down and say, not only are we not covering you for supplemental taxes or all these other things, we are not going, we're also disclosing this section here. We've had a lot of claims based on buyers buying property and not understanding they just inherited a PACE or a HERO loan. So read the prelim carefully, very carefully, right? Question everything, right? I don't understand this. Explain it to me. Great, we'll explain it to you. Or, God forbid, the title industry is full of just regular people doing everything. How many of you been to Starbucks? Really? Half the hands don't go up. Come on, be real. All right. Here's the reality of that. Do they get your order right every time? No. It's like going through the drive-thru at McDonald's. You're like, I know I ordered fries. Where are my fries? Right? It's that situation. Title insurance is no different. It's being produced by humans. They're searching things, they're typing things. They can and will make mistakes. So read that prelim and go, I think there should be something else here. The seller told me there was something else. You're missing a loan, or there may be a solar lien on there, right, that wasn't caught because it's human error. Right now, by the way, if we miss it and it goes all the way through and affects the buyer, that's what the policy covers. They can come back and lay claim to that, and we'll have to deal with it. But if we found out it should have been a disclosure issue from the seller side, we may be talking to the seller about restitution. So keep that in mind as well. So as we go into this, so through the exceptions, you're going to find the monetary exceptions. Again, back to the loans, PACE HERO type of stuff, liens, child support liens, federal tax liens, things like that. I'm going to give you guys a really interesting example. A lot of you will shake your head, no, that's not possible. It is case law. All right, here we go. Who can I use on this one? Who have not used yet? I'm going to use you two. Okay, your husband and wife. All right, I hope that's okay. That's fine. That's funny. He's more okay with it than you are, which is really interesting. Okay, so husband and wife, right? Bought title, bought home, 1980, right? You're a businessman. You're out there hustling. You're doing all things. You're a homemaker. He's just kicking butt, making money. You're like, this is great. Money's flowing in, raising kids. Everything's great. You're out there doing your thing. You have no idea what he does for a living, right? So then he dies. And this is true story. He passes away. We get the transaction, run the order, and you've got $500,000 worth of judgments against you. Right? You had no idea. You're like, what? Right? So what happened was that this transaction had been, not rejected, but there wasn't enough equity in the home to pay off all the judgments. There's no value to you to actually sell the property. And now you're afraid they're going to come collecting, right? This went through a couple of different title companies before it came to me. Case law. Husband and wife as joint tenants, established in 1980, has nothing to do with the date, but it's joint tenants. Is the key here, is a contract between spouses or between two people. Jules, you and I can be joint tenants. That contract superseded $500,000 worth of liens. So when you died, title passed to you, that debt followed you to your death, and those creditors were left hanging. We closed that deal, said, see you guys. Good luck collecting from him. Get your shovel out. Okay. So in this case,
Joint tenant, if one person has a lien goes with it.
it's a timing issue though, right? Let's go back and reorganize that a little bit. Acquired title in 1980, husband and wife as joint tenants. But this is what people do later on. They go, well, let's set up a trust. Now you have all those liens and judgments against you. You go to the attorney. You're going to be the attorney in this case. What can I do for you? I need trust. Fantastic. We set up a trust. You're not running his name for liens and judgments. You're just taking them from joint tenancy into a trust. That's your whole job. You don't know about the liens and judgments. She doesn't know about the liens and judgments. But guess what happened by default? Every lien and judgment now attached to the property ahead of the conveyance to the trust. So now, in that case, he passes away, they all attach. It's circumstantial, it's communication. How do we get through these things? I get call after call after call after call from people who say, is there a way through this? Is there a way around this? I'm not trying to circumvent the law. I'm trying to look at places that people are not looking in to find a way through. So you guys, I mean, transactions are just falling off the trees into your laps right now, right? There's so many you don't know what to do with. Every deal we need to find out about. Yeah.
So in that particular scenario, right, because they were joint tenants, once he passed away,
With him.
Therefore, there is no collection for the wives.
Correct. They could try. She just had no obligation.
Is the same as joint tenants?
No, no. So community property, so there's a difference between, keep this in mind, guys. So there's community property, and then separately, there's community property with right of survivorship. Community property with right of survivorship was created, don't quote me on this, you might want to Google it, 20 years ago, 25 years ago. It didn't exist. A lot of people thought, oh, I'm grandfathered over. If I hold title as community property and then the new law came into place, I'm automatically included in community property right of survivorship. No, you'd have to convey to the community property the right of survivorship. So regular community property doesn't protect you from that. Now, the follow-up question is, does community property the right of survivorship do? I'm not sure, to tell you the truth. I didn't dig that deeply, and I don't think there's case law on that one yet. The case law for the joint tenancy exists. It's on my desktop, so if any of you are interested, I will fire it off to you. I keep it.
And so I asked because we had a couple of different agencies, and they're like, right? So that is the one that I'm like, why?
Well, there's a couple of things there. A title company should not be picking out or advising as to the vesting anybody should take. That should be going through their CPA, right, to go, is there tax benefits or detriments to any way you hold title, right? I would literally, if somebody asked me that, I'd go, well, here's what this does, but I can't say this one's better than that one because I don't know the ramification that they may have within their estate planning process or tax liabilities. So yeah, I'd be very careful. Yes, ma'am. Uh-huh. Well, see, it depends, right? So let's say it's you and I, we're two single people, we have no relationship, we're investing or we're friends, right? I think that might work provided neither one of us have heirs on either side of the fence, right? Meaning that, because joint tenancy, I die, the moment I die, whether it's established of record or not, the moment I die, my last breath, my title transfers to you. Might take 10 years to record an affidavit of death of joint tenant, but it goes back to that very point that you died. So if you and I, single people, had other people in mind to inherit our 50%, that went out the window. And there's been fights on that a lot, right? They're like, well, I didn't know. The title company told me to do this. Do not do that, right? Now, I'll change it up a little bit, right? What if we are not married, but we're in a domestic relationship? Yes, that makes sense. Thing is, domestic relationships now have all the same benefits as a married couple now, right? So it doesn't matter. But I'm going to give you, here comes the other kicker on it. True story. It's funny, I keep looking for somebody. You're going to be my wife in this case. I'm sorry, I'm going to do it this way. My wife. Okay. There you go. There we go. So transaction was, you and I were entitled, husband and wife as joint tenants. Okay. Actually, it wasn't joint tenants. It was just husband and wife. There was no right of survivorship in there. So I get the transaction, right? And we go through and I'm like, well, got to probate the wife because there's no right of survivorship mentioned, right? It was just husband and wife. So I'm telling the husband, well, you got to go get a probate done. And of course, by the way, this property was in Lake County, if that tells you anything. So, all right, I will never tell that joke again. All right, so, okay, if I said it was in the South where Deliverance was shot, would that make any sense to you guys? Okay, so you pass away and title company saying, we need a probate on her. I get a call from the son, right? Son goes, mom's interest is mine. I'm like, time out, why? Because my parents were never married. So I talked to the husband and he goes, well, we're common law. I'm like, oh boy, you can hear the banjos playing now, right? That, thank you. That common law is not recognized in the state of California unless it's perfected through court. He would have to sue for that right of survivorship or commingled funds or assets, right? The son did his research and said, nope, since they weren't married, I'm first in line to inherit her 50%. I said, well, that's fantastic. Still have to probate her, right? Go to court because you're going to have that over. I can't take your word for it. Problem is, you guys talked about SIs, right? We get SIs on everybody. We look for social security numbers, driver's license numbers, dates of birth, where they've lived in the last 10 years, where they work, all this stuff. Do you think we ever verify whether they were ever married or not? No. We can't even ask, right? We can dig into the most personal things in their lives, find stuff of record, but we can go, are you really married? And you go, absolutely, until one of you dies and then the son shows up. So keep that stuff in mind. These are the things I run into. All right, so let's kind of jump in because we're burning up a lot of time here. So when we go back through these exceptions, the exceptions to me are the most important part to look at, guys. Read them through. If you don't understand them, call, right? Call your title company. It better be Stewart Title after this, but call your title company. And if the escrow officer doesn't know the answer, ask to speak to a title officer who will try to avoid your call at all costs, but have them explain these things to you. I don't understand. Can you help me out? And as I've already offered, if they won't help you out because they're afraid to be on the phone with people, they were also the guys who never went to the high school dances, by the way. So thank you. You may go, if I do stand up, you're going to be in the front row. Okay. So call me, send me a copy of that prelim so I can help you proofread it because my goal is to help you. We are a team, right? The goal is to do what when we get a transaction? Oh, you guys are horrible. All right. So here it is. So here's the SI exception that you talked about. Interesting here. Number 18. Okay, you guys don't worry. You can get slides of this. So when you read through it and you have questions based on the slides, call me up. This one says, any lien or right to a lien for services, labor, or material, therefore or there hereafter furnished, imposed by law and not shown by the public records. That was a really fancy way of saying, I think there was some work done on this property. Okay, if there's work done on a property, and by the way, if you're representing a seller and they call you up and say, I'm going to list my property, they're going to brag about everything they just did to that property. Come on in, you should have seen this place. It was a dump when I first got it. New floors, new paint, new ceiling fan, new kitchen, new plumbing, new this, right? You're going to go, red flag. Even if it's not on there, we have to deal with it because there are mechanics lien rights that exist and they supersede everything else. Now, let's say it was you, right? You did all the work yourself. You didn't hire anybody. You went to Home Depot. You did all that stuff yourself. Fantastic, right? We don't really have to worry about any mechanics liens because you're going to lien yourself. No. But what do we have to worry about if you did something to that extreme? Permits. Permits are covered under the policy of title insurance to the buyer. If they are not disclosed, they are unknown to the buyer, they are covered under the policy. Okay, that's another thing we're seeing a lot of now in claims. Why? Because everybody watched HGTV and said, oh, I can do that. And they do it. They don't always do it well, Or it's a couple of frat guys going, bro, we can do this. Come on. And they do it. And they do it poorly, right? I'll be right with you. So what we do here is, true story. I had a guy, tore a home down to the studs, moved walls, did the whole thing. Was not a contractor. He was a high-tech guy, but he watched videos on YouTube, how to do everything. Learned how to do copper piping, sweat the pipe, weld it, do plumbing, do electrical, do all of that stuff. He did not get one permit. Totally redid the house. I found out at about the 11th hour of the transaction. It was gonna close. And I'm like, what? I actually talked to him. He had no clue. He didn't do anything maliciously. He wasn't trying to hide anything. I said, did anybody help you do this work? He goes, well, yeah, the guys at the Home Depot parking lot.
Yeah.
I'm like, that's quality work. So we went through this. Now, did we close that transaction? Yeah. You know how I closed that transaction? Because I had the buyer and the seller on the phone at the same time and go, can you please tell them what you did? Because the buyer was like, this place is gorgeous. I'm like, okay, step one. He said, I didn't get permits for any of this work, blah, blah, blah. And the buyer said, I'll take it. Said, fantastic, let's put that in writing. And I carved out permit coverage from the policy so we could still issue them the best policy. I just carved that portion out, right? Because why? It was disclosed to the buyer. So we were covered to go, but it takes communication, right? And it was funny is because both the buyer's agent and the seller's agents were livid with us for discovering this at the last second. But it isn't like the seller. The escrow officer called me up and said, I think there was some work done on this. And the reason I knew that, by the way, if you get a prelim and the owner of that prelim or that property has owned it for less than 2 years, consider it a flip. If they bought it for $500,000 less than 2 years ago and they're selling it for $1 million now, why is it worth so much more? They did work. If they've done work and the evidence is, I just got this property, now I'm selling it, the mechanics lien risk exists in spades. And we need to deal with it. We can get the contractor to sign a lien waiver. We can get the seller to sign an indemnity, right, type of thing. So there are ways to work with it, but it's better to do it at the beginning of the transaction than when the buyer's got the truck there ready to move in.
Sometimes I'll be listening.
Uh-huh. Yeah. There you go. Or they're including that little addition in the garage that they did, right? Yeah. So you guys are the eyes and ears. And again, if somebody's bragging about all the work that was recently done, or if they did it themselves, just call.
So,
Hey, I think this is an issue. And it is.
over whatever if the buyer accepts.
Yes.
As is?
Yes.
Okay.
See, that's another thing. You say as is, but we would like to see things defined a little bit more succinctly, right? Because if, let's say you're the buyer's agent, you don't know if that was just done and how well that was done. You go, well, this is an as is sale. I think that term might be a little too ambiguous where buyers go, okay, you know, whatever. But if you see new floors, you're going in there and you see the new, you know, the stuff is new, right? Especially if the house was built in 1962 and you're like, well, I know these aren't the original floors, type of thing. Just question the seller. What did you do? Who did the work? It's an easy conversation. I had two hands. I'll be right. Yeah. Well, let's really give you worst case scenario, right? They did a ton of electrical work, move walls, stuff like that. Bad electrical catches on fire. No permit, right? The house is totally destroyed. That's a huge claim.
And the neighbors could be destroyed too.
Well, let's not even go down that rabbit hole, right? But that's where it goes. Or plumbing, bad plumbing breaks, floods the house, damages everything, water seeps up the walls. Title companies looking at having to care for a lot of that stuff on behalf of a non-disclosed seller situation. So we have to watch out for that. That's, again, I was just on a claims call and we're seeing an uptick in these things. Mostly we're seeing an uptick in these things is because the weather's getting better. We're having more houses go on sale. So therefore it's kind of, you know, is it really an uptick or is it just because there's more things selling right at this moment because of the marketplace? Yeah.
Isn't it, right now it's very common, there's a lot of flips coming out.
Yeah,
So as long as the seller is disclosing, we went ahead and renovate with or without permits. And as long as the buyer accepts, isn't that sufficient enough?
that is, but make sure it's in writing, right? Disclose that back to the title company that this is what we've done, right? Because again, title and escrow are separate parts of the same whole, right? But their communication isn't always really great. So the other part is some escrow officers may recognize mechanics lien risk where others may not, depending on their experience and things like that.
Let's say the seller probably question here in any intent.
Well, yes, it's really funny is that just the owner's affidavit is kind of what you're talking about there. You know, when I get the owner's affidavit, the day before it closes, and then I go, oh, look, they disclosed they did all this work, right? Title doesn't become involved proactively, right? I have to wait for my phone to ring to actually address any situation. That's why I'm here doing these, to try to get ahead of it. So we're doing it at hour 1, not hour 11. Right, which is really important to me because when I'm having these conversations with people, they're like, mad, why didn't you tell me this before? And I'm like, I literally found out 15 minutes ago that all this work was done on it. So that's real time to me, but that's like months to you guys, right? So back to that owner's affidavit, yeah, that's a disclosure and it's actually indemnity. So if they lie upon that, they have a liability. But if they tell the truth, thank you very much, right? They may be disclosing something that sets underwriting in another direction till we go, time out, we have to do this other stuff. By the way, if you represent people who flip property, or you're a property flipper yourself because you're doing real estate and flipping property, I'm happy to work with you so we can streamline that. So it's not like, oh, this is new every time. You're like, we did this last time. We've already covered these bases last time, because title will not remember you. Escrow will, title will not. That's why I'm like, hey, include me in so we can build that relationship. So you're not having to explain to me what you did every time you flip a property. That's called a relationship. It's called a team, right? So who wants to be on my team now? Anybody? Oh, you guys are horrible. I got 4 hands going up. Oh, well, thank you. How about you, Karen? You want to be on my team? Yeah. Perfect. Yes, sir.
Instead of disclosing thing, the house will burn down, will the homeowner insurance cover that burn?
It should, right? Potentially. Well, that's another thing is that if your homeowner's insurance, right, discovers that, well, wait a minute, this unpermitted work was disclosed to you, but wasn't disclosed to them. I don't know. I mean, that's another insurance thing. What's funny is, go ahead.
It doesn't disclose. Does title insurance cover that?
No, because if it was disclosed, then the buyer accepted that potential, right, type of thing. So again, the other part is that I'm going to tell you guys something because I ran into this and it had nothing to do with permits, but it did have to do with a fence that was moved, right? And I had a buyer call me after close of escrow and he goes, hey, I'm standing in my backyard and I have my assessor's parcel map. And he was in a court, right? And so the map showed it in a nice triangle. He goes, but I've lost about 50 feet. The fence was moved into my property line 10 feet this way, 50 feet that way. And he goes, my neighbor has a shed back there. And he goes, so I went around and asked the neighbor, hey, what's with this? And he goes, the guy goes ballistic and slams the door on me. And I went, okay. I said, can you tell me, does the fence look old? He goes, yeah, it looks really old. I said, okay. So it's a weathered fence, been there a while, right? I said, okay. I said, did the seller disclose to you that there was any sort of agreement between him and the neighbor? No. He goes, but my neighbor, his new neighbor next door, said, I was in a conversation on that driveway with the buyer's agent and the seller's agent about that very fence. And they said, yeah, don't say anything. So they knew. And so what happened was, I said, submit a claim because boundary line issues are covered under the policy. Submit a claim, right? So we can make you, the innocent buyer, made whole. We will deal with this in some manner. We will either get the fence moved or have to adjust it in some manner that's equitable to you, the buyer, who's now lost square footage, who's been paying for the privilege of lost square footage, by the way, right? So either make this guy buy the easement from you, right? Or move it back or what have you. So that happened. But what was really funny is that both agents knew and went, stay silent. All right, bad idea, guys. So if you see something, say something. If you hear something, say something, right? Because we can literally hurdle almost every issue we come up to. We just have to address it. And again, that's communication. Keep in mind, guys, title insurance isn't perfect. How many people here have car insurance?
Everybody should have.
Yeah, it's those hands that didn't go up. You guys leave the parking lot first. Okay. You're exchanging money for risk, right? Based on your driver's record, right? They're saying that'll be $500 a month. Okay, fine, right? Title insurance is the exchange of money for potential risk. It doesn't have to be perfect. It just has to be mitigated and as close as we can get it. Same with any other insurance, right? So if you're like, hey, you're not being reasonable, this doesn't work, or you hear from escrow saying, my title company requires you to do something, and you go, that's nuts, right? Call me, because that's how we bridge those problems is through communication. Yeah.
It's the issue that you just mentioned about the fences.
Yeah.
There's like a property and the owner, turned into rental property. It's been, they own it for more than 30, 40 years. When it was, it's a rental property, but then they didn't know that their neighbor, who is kind of like a car, used car sales, and then they actually move their fence into their property.
Right.
And they have no idea, it's probably done over 10 years.
Mhm.
But then when they are about to sell it, the agent kind of look at the aerial and then look like the fence has been moved.
Yep.
So how do they get their, Is-
Move it back.
move it back?
Well,
If the car person said, well, we always have this
Yeah.
here and.
So the way to fix that will be through court, by the way. But, oh, absolutely. Unless you can make an agreement. But here's where the communication comes in, right? The used car salesman guy ended up with more property than he's paying taxes on by basically predatory move by moving the fence, right? Now, whether it was 5 years ago or 10 years ago, and they may say, well, adverse possession. It's been there so long, you can't contest this. Well, that doesn't really work if you're the victim of that because you didn't know it, right? You can't just go, okay, this is mine and I'm claiming it. And because you didn't know, right, I get it by default. No title insurance is going to insure that, right? I would have a conversation with that used car salesman guy and say, guess what? If you do not move that back, you're going to be in court and you're going to lose. And these are the reasons why you're going to lose, right? Or I'm going to say, how much are you willing to put up to fight this to potentially win? And if you're willing to spend that much money, you might want to just buy that property from them, make it legit, do a lot line adjustment and make it right. Because the homeowner who lost that square footage was paying taxes on that property of which this guy was enjoying. That's illegal. You can't do that, right? I'll give you one, well, we can do a little bit longer because we're here at 12:30? 12. Let me tell one more quick story, guys. True story. Condo neighbors, right? Condo A, man was in there, elderly man, has an emergency. Paramedics show up, take him out, go to the hospital. He never comes back. The door's left wide open. The neighbor goes, wow, nobody came back. So she waits a while. Says, well, I guess I'll rent it. She gets renters in there. Okay, she pays the property taxes because he passes away. Collects rent for 5 years. She's also the head of the HOA. All right, there you go. After 5 years, she gets an attorney and sues for adverse possession, and she's been paying the property taxes for 5 years. She won, right? Court's grant because nobody contested it. She held it for 5 years. If anybody wanted it, they could have come after it. The attorney did do a search of heirs to this man's estate, found 2 people in the deep South who did not have the money to contest. And just to make it palatable, she offered them each $5,000 from the sale of the house or the condo. in San Francisco. 2.5 mil. There you go, guys. So thanks, Jules, you're up.
Thank you everyone for attending, and we had some good questions on easements here at the end. Just so everyone knows, Scott does a monthly Zoom training as well, and our topic on this coming Monday, the 20th at noon is going to be understanding easements. So if you want to get on the list for that, come grab my card, send me an email, and we'll get you on the list for that. We'll also be coming back to SCORE in a couple months for preventing elder abuse, preventing, not a how-to.
Yeah.
Correct.
Fidelity does the how-to class for you. So.
Yes, and we'll be sending. Yeah, only funny to us. So we have monthly classes coming up. We have tons of other resources for you, a great escrow team. So please feel free to reach out. I will also send out a copy of the slides once Jody gets me the attendance list. But if you want them sooner, go ahead and grab my card and we'll get them emailed to you tomorrow. So thank you everyone for attending, and thank you, Scott.
Thanks, guys. Thank you.
Please fill out the feedback cards if you can for future class ideas. We'd love to grab those from you too.